with that, I'm going to go through things. I'm not going to try and make you lawyers, but I'm going to try and give you an understanding of some issues. And there's going to be a constant theme between what Jennifer has spoken about and what I'm going to talk about, in that I'm going to talk in terms of science not being applied properly and misinformation that's being put forward as science. So there is a constant theme there. And if you think in the context today of the PwC scandal that's going on, where reports are prepared for government, being paid for by government and being called independent, it kind of fits the theme. I'll start with the slide. Water is so important to everyone. We all know we're in the driest habitated continent, so it's something that should be precious, okay? I wanted to start with the United Nations description of what water security is, because I wanted something to commence with. One of the things that I'd really like you to consider, and I'm going to be asking you to think about this as we go through the presentation, is the good governance, adequate legal regimes. That's the area that I play in. All of those items are the items that have, ever since water's been something that we need, been balanced. So there is no difference going forward. We're going to be balancing very similar competing interests. When I looked at the ecosystem side of the UN Water Security Chart, it made me think of what's happening with aquifers and soil subsidence, because when we're talking about ecosystems, water security, we're also talking about how we use water, what damage can occur as a consequence of the use of water. And those are issues which are coming to the fore. Okay. The fact that these issues have been around for a long time is shown in this extract from Hansard to do with a parliamentary debate on the 27th of October, 1891. Okay, this was prior to the introduction of one of our early pieces of water legislation. And you'll see the reason that we need to balance is because it's going to ensure the prosperity of everyone in the community. So if we get the balancing act right, that's the outcome. And that's the driving goal. We want to try and get that outcome. But you can see the other part of the debate in Parliament back then was in relation to who's going to pay for what. They were talking about the drovers coming down from South Australia and using something built in Queensland. Who has to pay for that? This is where there needs to be that collaboration between government and community. And if that's done well, things work. If it's not done well, then we have some problems. Okay. If we can jump. Okay. This is where I'm going to get into a bit of technical law. As I said, I'm not going to ask you to be lawyers, but I'm going to ask you to consider this question, referencing back to that UN water security. Do we have an adequate legal regime? Okay, this is what I want you to think about as I go through these next PowerPoints. We're going to start with the, back one. We're going to start with the Roman law. It's still applicable today, so I'll come to that. You'll see there that this is an extract from a paper by a judge called Brian Preston. He is a judge that has been very vociferous in relation to climate change actions brought around the world, and they're based in part upon this concept of Roman law. There is an opportunity for us to think about that in relation to water law. So when you're talking about things like water, they become part of what's called the re communis. They're the things that aren't owned by an individual. So water, air, the seashore, those sorts of things are common. They're things that we all have to have, and they ought not be owned. You can see in the statement from Brian Preston that he says that there is no private ownership. But then he talks about a vesting, and I don't agree with him that the asset itself is vested, but the right to manage it is vested in the state. But he then talks about there being a fiduciary duty. That comes into play where the government is working the balance out about how it allows us to deal with water, or how it manages the dealing with water. And that's the important thing. If that fiduciary duty is dealt with properly, things work. When it's not, they don't. And we're going to have a look at some examples where they don't work. Okay. So that Roman law was brought into the English law, and these are statements about the common law. You could drink a river dry, you couldn't pollute it. You could drink an aquifer dry, but you couldn't pollute it. If the water passed across your property, you had that right. That was a riparian right in relation to water. That applied under the common law. And you can see that the common law position was that no one had any property in the water itself. No one owned the water. All right? Now you might be thinking, hang on a minute, I've got a water allocation. Don't I own something? I don't think you do. Except, this was an exception, that a particular portion which might have been abstracted from the stream. So the old riparian rights used to be that if the stream comes past and I take the water off and put it in my dam, I've abstracted it. If I go down to the creek and take a drink container, put the water in that drink container, I have abstracted the water from the stream. I then have a proprietary interest in that water. Doesn't mean I own it, because as it passes through me or it gets used on my farm, it goes back into that water, which is part of that common. It belongs to everyone, just like the air you breathe. You breathe it in, you breathe it out, someone else breathes it in and breathes it out. Same sort of concept. That law has been applied in Australia. So, we go back to 1891, okay? And back in 1891, following those debates, we had the water legislation that was introduced back then, the Water Authorities Act, and you can see there the management and use of the water was vested. The property that they're talking about, the property in the legislation, was the pipes, the dams and that infrastructure. That was clearly owned by someone. That was owned by the state. But the use of the water was the thing that the legislation gave rights to, not ownership of the water. So that's a very important point. Paragraph 8 was always in this legislation. So subsection 8, the quantity of water which a consumer may take or consume for any specific purpose may be regulated under a bylaw. That was always the law. As we move forward, we had, the introduction of the Water Resources Act. And under the Water Resources Act, we had a specific section which protected the right that you had in relation to riparian water. Okay? You could take water from a watercourse if your property bounded on it. It was the same right that was under the Roman law, under the common law, that was brought into Australia at the time of occupation and then applied as part of our common law and then put into statutes. A and B, domestic purposes, watering stock. There's some additions that are going to come into that. The vesting that happened here, this vesting was not property in the water, but it was in relation to the weir, barrage or dam. So again, the thing that vested in the Crown wasn't the ownership of water, it was the infrastructure. Okay. Then in 2000, Rod Walford introduced to Parliament a new act, the Water Act. There was a lot of debate around that. I've read, before coming here today, the extracts from Hansard in relation to that debate. And there is a misunderstanding, in my view, in relation to what that law provided and what was provided under that. There was an assumption that there was actually a right in the water itself, an ownership of the water in a lot of that debate. I don't agree with that. I think that's wrong. But what it tried to do was vest the use, flow and control of all water in Queensland into the state. That was consistent with earlier legislation, not inconsistent with a riparian right. But then we added in where water from any of those sources was collected in a dam. That bill was proposing to take part of that right away, because previously if you abstracted the water from the stream, put it in your dam, you had a proprietary interest in it, not ownership of it. That proprietary interest has been removed from you. That was the common law position. Okay. The next clause in the bill was again trying to then maintain that riparian right, that common law right, but remembering it was going to be modified by the ability to have water in a dam still controlled. So what happened with that? Okay. This is out of reprint number 1 or 2 of the bill. This is the section that should have gone in. And it never ever did commence. Okay, so the riparian right was in the bill, it was debated in Parliament, but when the bill became an act, that section wasn't commenced. Okay. So, what we have, what's all water? Water included those things that you would expect, but now we've put in CDB, underground water, overland flow water, water that has been collected in a dam. Recycled and desalinated water's also gone back in there. I think that's not necessary. If the water actually is never owned, but there's a proprietary interest in it, when it goes back into whatever system it is, then it becomes government. But the government wants you to be very clear that every time you flush the loo, it's their water. Changing the way things are dealt with. So the common law was changed as a consequence of particularly paragraph D. Ownership of the dam was caught. Now I said to you that this is caught up in our current law. Okay. I'm going to run through a prosecution in the Northern Territory in 2018. So this gent goes down to the army base with his water truck, comes up to a standpipe, puts 15,000 litres in his truck and drives off, comes back and does it a second time and gets caught the second time. He gets prosecuted for offences, being on the defence property without a pass, but also for taking the property of the Commonwealth, the water. He pleaded guilty to being on the defence base without a pass, but he said, hang on a minute, I'm not guilty in relation to taking the water. Okay, here's why. The argument before the court was, can water be owned? So I'm talking about 2018, and we're talking about water being viewed as a public asset. This is the Roman law coming back through in a current prosecution. Need to regulate use of water, and the Water Act defined water in the same way that we do, that it related to the use, flow and control. So our Water Act has exactly that same language in it. So this case was very relevant to what our legislation says. Okay. There was a consideration of what had happened with the water. We have public bodies that actually take charge of water. So, the state government builds a dam. The dam then feeds water into a council treatment plant. The council then run pipes to your house and they put a meter outside your house. Very similar to this sort of thing. We had that process in the Northern Territory, but with a standpipe on a Commonwealth government defence base. No different. That organisation then distributed the water and charged a fee for it. Same thing. Okay. So the court considered this, and it confirmed that because of various other judgments that there was no ownership of the water, so there wasn't ownership of the water. And if you think about a charge of stealing, you have to take something that belongs to someone else. So if there's no ownership in the water, this was the argument that was being put forward. No ownership in the water, how can I have stolen it? It's a commons, it's something I have a right to. They confirmed that that was the situation, and that they confirmed that as the water flowed over someone's property, that the person didn't own the water, but had the benefit of that water whilst it flowed. They referred to the Old English authority of embryonon. It's an authority that I've seen and referred to many times. No one can have property in the water itself except in the particular portion which he may choose to abstract from the stream and take into his possession, and only during the time of possession. Okay. So the court then considered, well, what happens? How does property pass in that water as it goes along that chain? They said that those water corporations, by acquiring and treating the water, had abstracted it. I agree with that. So they then have not ownership of the water, but a proprietary interest in the water. It gave the Commonwealth, when they put it through the meter and it went onto the Commonwealth land and was in the standpipe, the Commonwealth then had a proprietary interest in the water. Okay. And this is where I disagree a little bit with the judgment. The court said that the Commonwealth hadn't done anything to take physical possession of the water. I don't agree. As soon as it's gone from the property boundary through that pipe and is in the standpipe, they have taken possession of that water. So I think the court got the right answer, but not quite for the right reason. So that whilst that water was abstracted, the Commonwealth had a proprietary interest in it, and the person turning the tap on to take that water away from them had taken a proprietary interest in something, not the property in it. And so they were found guilty. So, our law in relation to water at a broad level hasn't included riparian rights. It's now picked up that the water that you put in your dam and you abstract is now no longer protected by those riparian rights. We're going to trade water. When you get a water allocation, what property are you actually trading? It's an interesting concept as a lawyer. It's not a property that can have ownership, but we trade it. We've included recycled water. This is a way forward for me. I said there was a constant theme going between what Jennifer was saying and what I'm going to be talking about. There's a fiduciary duty on the Crown to deal with those things which are commons in a way for the benefit of the whole society. And if they don't, actions can be run against governments which are outside of their statutory framework. So Parliament can go and enact a bill, and someone could go to court and say, hang on a minute, they can't put a bill through which means I'm going to die, or they've misappropriated this water in such a bad way. They can't do that. So that fiduciary duty, it's a potential legal avenue. So again, coming back to the question from the UN Water Security PowerPoint, do we have an adequate legal regime? I don't think we do, because I don't think we fully understand it. And to jump onto is material in relation to different standards that are applied, and this is really going to come back to that science type question. What science gets applied? How does it get applied? And whether there's a need for consistency in standards. But again, ask yourself the question, do we have an adequate legal framework? One of the things that I will be suggesting is that there's a need for amendment of legislation. That comes out of this context. I'm going to look at three different types of dealings with water, where you make an application for water allocations for your farm, what standards you have to meet. I'm going to look at the standards that are applied for plan making, regional plans, water resource plans, and then I'm going to have a look at the standard that resource projects have applied to them. And we're going to show the stark contrast between those different standards. So, the Water Act, the criteria for deciding, includes a lot of sensible things, the sorts of things that you would think need to be included. And I particularly identified the last few. Information about the effects of taking or interfering with water on natural ecosystems, we ought to know that. Information about taking or interfering with it on the integrity of the watercourse, lakes, springs or aquifers. And when we talk about the integrity of those things, keep that in mind when we're talking about the ability for resource projects to take. Strategies and policies for water resource management. And that's typically your efficient, continued use of water. How well you use that really valuable asset in the public interest. Now, I'm going to refer to a case which was an earlier case, de Tournau. I didn't act for Mr. de Tournau. He went to court. The criteria there is pretty much the same. That's the only reason that PowerPoint's in. So there's not really a difference between the current law and those provisions. Okay. The court identified in the Queensland Court of Appeal, so we've gone to a member in the Land Court, an appeal to an appeal which ended up in the Queensland Court of Appeal following that other legal steps were taken. But the court there recognised that their broadest cases of that nature, so we're talking about you applying for a water allocation, are concerned with three elements: the availability of water for the allocation, the potential environmental impacts of making that allocation, and the use to which the allocation will be put. Now, a lot of that use component comes out of your lower order documents, your ROCs, your water plans. But that's the fundamental principles, and that makes sense. So, in de Tournau, there was a dispute in relation there was a dispute in relation to the evidence in relation to the availability of water. It was a complex issue. We were talking about the Golden Triangle back of Atherton, North Queensland here. We've got a short aquifer, an aquifer that's got a life of tens of years, not hundreds of years, not like the Great Artesian Basin. So we've got water going in and coming out fairly quickly, but it was looking at the evidence that was put forward by the department by a gent called Dr. Prendergast. The court found they couldn't safely rely upon the evidence that he had been putting forward. The water, the WAG, Water Assessment Group, I think that's the proper title, had been saying to the department all along, your science is all wrong. They were ignored. Same sort of thing that Jennifer's talking about. People in authority taking a particular stance for whatever reason. So the court, as the matter progressed, and because Dr. Prendergast's evidence wasn't generally accepted, the Crown, so the department said, listen, let's just proceed on the basis that there's an assumption that there's available water. So the third element was the element where de Tourneur failed. He failed because he didn't provide sufficient information about the efficient and continued use of water. Putting his application in context, there were applications that were made which simply said, I would like an allocation, no other information on it, except so that I can sell water rights when they come in. That cannot be an efficient use of water. There were other applications that were made over volcanic cones. I'm talking about volcanic rock where you couldn't irrigate anything on it, and they were approved. So there was a myriad of applications that we sought in a later appeal that showed all of that by way of evidence. So it's not surprising that Mr. de Tourneur, in the context of how everyone else had been making applications and being granted allocations, didn't include sufficient information. It was described to me as his farm management plan was the sort of thing that would have gone on the back of a packet of cigarettes. It was that sort of detail. It was nowhere near enough. So I then acted for these two gents. These two gents had the courage to take this forward. It cost them a lot of money and it took a lot of effort. Anytime we run litigation, people have to know that it's going to be expensive, it's going to be costly, not just in money terms, but in stress and management. They took it on. We're talking about allocations of 750 megalitres and 990 megalitres coming from the same aquifer. As part of the same allocation, we know that there was interconnectivity between the surface waters and in the two creeks. We knew that it was a quick recharge aquifer. We knew, because of chemical signatures, about that connection. And there was a disagreement in relation to modelling. My client prepared a hydraulic model. They actually spent the money to prepare a hydraulic model that the state ought to have done properly in the first place, but hadn't done. We engaged Neil Sutherland to prepare crop management plans for the farms. Those crop management plans went to the detail of identifying centre pivot irrigation, the circles around those centre pivots, cutting out the corner edges off of the property that weren't covered by that centre pivot irrigation to say that's not going to be irrigated, therefore we can't count that land, taking out the tracks, taking out the houses, working out the crop rotations, working out the spelling of the land. All of that material was put forward. That was the extent of the evidence my clients had to put together to gain an allocation of water, and we're talking in terms of 750 and 990 megalitres of water. That was the extent of information they had to put together to get that. The process took years. From 17 February 2005, when they made their application, to 5 April 2012. That's how long that process took them to get their allocation. And that wasn't the end of it. That's only from the judgment of Member Smith, who was in the Land Court, the first of the judgments. We then had to go on to appeal further in court. He's apologised. He said, this is crazy. How can these people think this is a system that's working? Ask yourself the question, does the legal regime work? I don't really think it does. Okay. The other thing that came out of the case was very important. There was evidence given by Mr. Bell, who was a person who worked within the department. And because we obtained every application and allocation that was granted, we were able to show that not one other had complied with the requirements of the legislation for the granting of an application. Not one. The only two people who did were Gallo and Williams. That was it. Every other one had. The court recognised that there was maladministration as a consequence of that. Part of the, and the court fairly said, look, this case wasn't about working out who's done what wrong, but they recognised that there could be a myriad of reasons why that had occurred. But the court did say, I want this referred to the Crime and Misconduct Commission. The Crime and Misconduct Commission got it and said, back to the Ombudsman. The Ombudsman got it, had a conversation with someone in the department, and nothing further happened. Okay, so again, it's one of these things where I don't think there's sufficient accountability in relation to these decisions being made. That's part of our system. So in that catchment, the planning in relation to water was based on incorrect information in relation to the availability of water, and water allocations were granted for all sorts of improper purposes.